All right, it's 1:35. I think we'll start. And of course, you know now it's the Bond and Brown law firm, PLLC. So Chris here is my partner. And Chris, why don't you start us off today?
All right, will do. Well, welcome to our seminar exclusively for our clients. It's called the 8 Deadly Mistakes. And what we're going to talk about is the ways in which clients routinely destroy their estate plans. And so here at the Bond and Brown law firm, we are highly dedicated. I mean, there's a true purpose to us seeing that your plan works through time and the way that you want it to. And so we want to check in regularly and make sure that you're still on track. And so today we're going to talk about a variety of issues on how you can get off track. And so first of all, congratulations. Congratulations for what? Well, you've shown up to talk about death and taxes, nursing home expenses, families torn apart, and that your plan may not work. Well, that's all pretty serious stuff, but so we appreciate that you attended the webinar. And you know, as clients already, you've already taken steps to address these issues. So you should know you're better off than most of the American population. But from time to time, there are reasons to take a second look at your estate planning. So a quick introduction of myself. I am born and raised here in the Houston, Texas area, and went to high school at Cypress Springs High School, and that's actually where I met my wife. We've been together since we were sophomore in high school, and couldn't be more happy about that. She's been with me every step of the way. And the reason I mention that is family is extremely important to me, and I know it is to Bob as well. Well, I did my undergraduate degree at Texas Christian University, go Frogs, and I majored in finance and supply chain management. Well, after I got my undergraduate degree, I worked at Lockheed Martin Aeronautics on the F-16 program for several years, and it was a great experience. But I knew I wanted to push myself further and get my family down here to Houston, so that, you know, it takes a village to raise a child. So we wanted to have some more help down here in Houston. So what I did was I went to the University of Houston Law Center. I focused almost exclusively, as much as I could at least, on transactional law and estate planning. And after law school, I worked for several years managing assets for a large family limited partnership. And then I met up with Bob, and really am blessed, and I'm super grateful to have met Bob, because now in my role as a estate planning attorney, I get so much more than I ever got managing just assets. I get to deal with families. And I mean, Bob, you can attest to this. That really is where so much satisfaction and purpose comes from this job. And so I really am blessed to be able to help families. And it's a lot of trust that families put in us to be able to plan their estate. And we take that very seriously. And that's why we're so dead set on making sure that this thing works, because a general purpose, you know, reason why we take so much satisfaction in our job is that you gave us all this trust. And so we want to make sure that the job is done right and you see your wishes carried out.
Well, thanks. Let's see a little bit about me. I'm a native Texan, grew up in Dallas. I went to Southern Methodist University right there in Dallas. And then when I finished my last exam at Southern Methodist University, I found a draft notice in the mailbox. And so my occupational direction was set by the United States Army for the next few years. So I went through officer candidate school, was trained as an infantry officer. And then although I never intended to make the Army a career initially, I never got out. So I was in from 1969 until 1989, and I retired as Lieutenant Colonel, Infantry, Regular Army. And however, I'd always thought that at some point I would go to law school. So the next month after I retired from the Army, we moved back to Texas, to San Antonio, and I went to law school at St. Mary's in San Antonio. 3 years later, I'm a newly minted attorney. I'd also passed the CPA exam, And so I moved to Houston because in order to be a CPA, have that designation, you have to work for a CPA. So I took a job with Arthur Anderson, which this was before their great downfall in the Enron fiasco. At that point, they were the largest accounting firm in the United States, and they had 1,200 people in the Pennzoil building downtown. And they hired a few attorney CPAs for their tax department. So that's why I moved my family to Houston. That's how we ended up here. And that's where I worked for the next couple of years. Then I decided that I would start my own law firm. And of course, when you start a law firm, there's a lot of different things you can do. You can, you can defend criminals, but I don't like being around criminals. And most of them are guilty anyway, so it seemed like a very unsatisfactory arrangement. You can sue people, but I had had some practice with internships during law school, and I wasn't impressed by that. And then you can do family law, which sounds nice, except as you may know, family law is all about divorce law. And people who are divorcing are unhappy, and they want their attorney to be unhappy with them. And this was not suited to my more sunny disposition. So I decided that estate planning and probate and related areas of law were more constructive and more, a chance to do some good for folks. And of course, when I started out, I wanted to run a good business, but as time went by, I really came to think of this as my calling. And all the people that are associated with the law firm now, and most of them have been here a long time. Stephanie's been here since 1996, Kathy since 2000, Mary, who's our office manager and the brains behind the scenes here, she's been with me for 7 or 8 years now. Les, who works in our Medicaid area, we've worked together for, 8 or 9 years, I think. And so we have a lot of continuity, and all the people here are committed to this idea that there's no better work than taking care of families, helping families protect their own families. And so,
if you don't mind, real quick, just a bit of housekeeping. For those of you who are viewing, just some little hints and tips for while you're watching. For starters, you should see the slideshow on the main screen, and then there's a bar with our picture and then potentially some other pictures beneath it of other viewers. If you click at the top, there's a way of minimizing that so that you just see Bob and I. Additionally, if you have any comments or especially any technical issues, so you can't hear us, can't see us, then please just click on the chat button at the bottom and type it in, and we'll try to get that issue addressed as quickly as possible.
Yeah, good point. Yeah, we want to make sure you can hear and see us okay. And of course, it seems like more and more of us are using Zoom, and we're getting better at it. But every time I get on here, there's like something I need to learn or could do a little bit better. So if we can help you, chat something in there to Mary's also on here at our office, and she'll help you or assist you with that, or we will. So let us know if you need help. All right. Well, so I was just finishing up by saying that that we're committed as a firm to this idea that there's no better work than helping our clients take care of their families. We have thousands of families that we've helped in the Houston area, so we feel a responsibility to them, and we want to help as many others as we can. So what are we going to talk about today? Well, the problem is that after you have your estate plan set up, there's still a lot of different things that can go wrong. And a lot of this has to do with over time, things change. And if we're not alert, or if we think we can keep putting this off, you can get in a situation where your estate plan does not work the way you want it to when it needs to. And so what we want to do is provide this workshop as a way to kind of bring you up to date, to review some areas that you may know need attention or haven't thought about, and this will bring those to mind. And so on this page, we got a whole bunch of different ideas of things that can go wrong, everything from tax benefits lost to assets going through probate when that wasn't what the plan was, and so forth. Now, as far as the presentations going, we've divided this into the 8 deadly mistakes, we're calling it. And so there's a list of them up here. Starts off with not keeping up with changes in the law and not updating your plan to reflect family changes. No plan to deal with nursing home costs when that's a concern. Funding, or the way your assets are titled, is not set up correctly, or is not part of your trust if you have a trust. Or plan assets don't work out. The life savings, the investment planning does not work out for the family. Or the family is unaware, other family members who are going to actually be your trustee or your executor or your agents are unaware of what their responsibilities are, where to find the documents. Or the plan doesn't reflect anything about your own family values or family history. And if you thought about that, maybe that's something you definitely want to include with your estate planning documents. So how come we don't get around to this stuff? Well, it's because we procrastinate. Everybody procrastinates to some extent. Now, Stephen Covey, in his books, the 7 Habits series, he says there's 4 activities of life. And one of them causes all the trouble. The first area of activity is things that are important and urgent. And if something's important and urgent, and we're going to be competent people, we got to deal with that. So we deal with that. And then there's stuff that's urgent but not important. And it seems like those fill up our days. That's all the text messages we have to respond to, and the emails and the phone calls and all that stuff that need to be dealt with now, but in the great scheme of things aren't that important. And then there's stuff that is not urgent and not important. And we like to spend time there. That's drinking coffee, watching TV, and enjoying the activities, hobbies and so forth that we like. And so then there's one other area that causes all the trouble. And that's stuff that's important and not urgent. And estate planning is a classic example. And that's why it's so easy for us to put this off. It's like a monster gets to hold these kinds of projects. We know we need to get them done, but we decided we can't do it this week. And so we'll think about it in the future. And it just goes on and on, rolling into the future. Here's a cute little cartoon. It says, we got this turkey that's gone in to talk to the estate planning attorney. It says, with Thanksgiving around the corner, I thought this would be a good time to review my estate plan. Well, now, the turkey, may know when Thanksgiving is. But our problem is we don't know when the end comes, when we're going to become disabled or pass away. And we always, with our our planning by wishful thinking, we always say, well, I got plenty of time to address that. But then the fact is, none of us know when our Thanksgiving is coming. So with that, let's talk about what the problems are that you may want to consider as you're thinking about your existing plan. So the first one is not keeping up with changes in the law. And as the slide suggests, stuff is shifting around all the time as far as federal laws, state laws, all kinds of procedures. And many of these don't affect us, but some do. So just for example, on the income tax planning, a couple of years ago, we had a big change in the income tax rates that helped a lot of people. This year, right before Christmas, they passed a new law called the Secure Act that affected IRAs. And so for most clients that I have been doing estate planning with over the years, their individual retirement account is in many cases their largest or one of their largest assets. And in the past, if you left whatever was left when it went to your children, they could stretch it out, the distributions out over their life expectancy, and it made an inherited IRA very desirable. Well, this new law says there's no stretch to kids. They have to take it out within 10 years. So that is a big change in the way that people are going to be thinking about the value of IRAs and then how to handle this when it goes to the kids. For example, many people are going to consider the idea of converting to a Roth as much more desirable than the current setup with their traditional IRA, just for one example. Healthcare powers of attorney, the The laws have been set up in every state that deal with healthcare powers of attorney, and periodically they change. So clients of ours who have done planning have healthcare powers that are in good shape, as long as you have the right agent's name, still have the right agent's name. Healthcare powers that were done before 2003 are not up to date. The ones done before that, 2004, 2003, didn't have to deal with the problems of you need to have language about access to medical records. Powers of attorney. The financial power of attorney is different from medical power of attorney. So financial or administrative power of attorney, they're also called statutory durable powers of attorney. These are very important documents. You want to make sure you got the right people named as agent. And there have been some law changes. There was a law change a couple of years ago that got a lot of attention in the newspapers. However, if you have a power of attorney that was done at any time in the recent years with us, it's a strong, effective power of attorney. But you want to make sure you have the right people named as your agents if there's been some changes in your family. Medicaid planning. So Medicaid is the program that will pay for nursing home care. Medicare won't. Medicare pays for nursing home care just long enough to confuse everybody, otherwise known as about 2 or 3 weeks in most cases. So it's Medicaid that will actually pay the costs. Now, for some of our clients, their assets are such that they can't qualify for Medicaid and wouldn't want to consider that anyway. However, people with more modest estates, then if the husband or wife needed care in a nursing home, they don't have long-term care insurance, it's extremely expensive. So we're going to talk more about that in a minute. Mistake two. Is this mine job here?
I'll take over to you. All right. So the next mistake that's commonly made, I mean, with the changes in the law, you really can't control that very much. Same's true with changes in family. And so you want your documents to reflect any changes that might happen. And so, first of all, with the power of attorney agent, I actually dealt with this morning, where the people who were set up as agents originally have gotten older in age, and there's another generation who can step in and take their place. Additionally, there's instances where, we're people, we're humans. It's not always a straight path up. Sometimes people go through hard times and face challenges, and while they're going through that, you might not want them to be your agent. And so you just have to constantly be aware of who is designated to serve that role for you, and whether that's the person you want it to be or not. A lot of times, actually, with that new generation coming up, it's parents who would like to have their kids as agent, but the kids are too young and they really don't know their responsibility level. But as years pass, they realize, okay, they're suited for this, and I'm comfortable having my child as an agent. Additionally, with new beneficiaries, so if there's births or adoptions, then you're going to want to update your planning. Now, it doesn't have to be updated as long as it names a class of beneficiaries. But another issue to be aware of is divorces in your family. If there's been a divorce, well, you want to make sure that the planning addresses that issue. Insurance and retirement plans, this is another big one, especially if there's new beneficiaries. You're always going to want to make sure that those are up to date. And what you don't want to do is work on wishful thinking. And that's how this happens a lot of times, is wishful thinking. So be alert, be aware, and check your beneficiary designations. All right. Again, talking about divorces and marriages. So if there's a divorce or a marriage, again, you're going to want to have your documents appropriately updated to show for that. And there's a variety of different ways in which that might, shape up. And we'd have to talk about that in our personal consultation to see what needs to be done to address the changes. But what you don't want to do, so here's an example. if everything is supposed to go to your son just outright, free of trust, and then he gets married and you're not too fond of the daughter-in-law, well, you might want to reconsider leaving that money in a legacy trust, and your son could have a lot of discretion with that. But by it being held in a legacy trust, there would be divorce protection, so that daughter-in-law that you may or may not be too fond of doesn't walk away with at least half of those assets that you left for your son. And so there are things that can be done to address these issues. How about you cover stake number 3 for us?
Okay, so we're going to talk about a little bit about nursing home costs. And of course, a lot of people, that's very, this whole idea of needing nursing home care is somewhere between appalling and difficult to think about, because it's expensive and no one wants to go to the nursing home. And so I've had many clients who said, I'm not going to the nursing home. Of course, the problem is, at the point we're going to the nursing home, we're not going to be in control of our own situation in most cases. And in most of those cases, our family doesn't see any other option for us once we've reached that stage. So denying that we're ever going to do it is really not, doesn't say very much. It's just hard to say how this is going to play out. But we know if someone does need nursing home care, it is very expensive, because if Medicaid doesn't cover it, it's private pay. And in the Houston area, the average monthly cost for nursing home care is $5,250 a month, or about $63,000 a year. So that kind of drain on a person's retirement savings can just be disastrous if it lasts too long. It can create all kinds of anxiety for the family as well. So one of the areas that we work in is helping clients qualify for Medicaid. Now, there are 5 ways to pay for long-term care expenses. One of them is you can use your own money. Another is you can buy long-term care insurance. Another one is that you can apply for limited Medicare benefits. Normally, people aren't applying for it. What happens, the way Medicare is triggered, is that someone has a stroke or falls and breaks a hip. They go to the hospital for a period of time, and then they're discharged to a nursing home or a continuing care facility because they need rehab. And that's what Medicare will cover. It'll cover custodial care in a nursing home during the rehab period. Typically, this is only going to be a few weeks. When the rehab ends, or when the person can't improve anymore, as soon as that rehab period ends, Medicare stops. If the person can't go home, they still need custodial care, then it's private pay, and we start that $5,200 or more of monthly cost. And it's Medicaid that would cover it. Now, when you first hear about Medicaid, it sounds like you have to be flat broke to qualify. So we'll talk about that more in just a second. Let me get the 5th one here. Veterans aid and attendance can be very helpful for many people. So here's how this works. If someone is over 65 and they served on active duty during a wartime period, essentially since about World War II, and there are many, many wartime periods. So I would say most veterans who served on active duty also served technically during a wartime period, even if they weren't in a war, and so potentially qualify. So here's the deal. If you're over 65 and you need some kind of help, it might be assisted living, it might be in-home care, but whatever amount of care you need, that taken with your other expenses is more money than you have on a monthly basis, then that person can potentially qualify for VA Veterans, the aid and attendance benefit. The aid and attendance benefit is from about $1,000 to about $2,200 a month. And also, the widow of a veteran can qualify for a slightly smaller benefit. But at any rate, this can be helpful in paying for in-home care. It can be helpful for paying for assisted living if the person can qualify. It's not enough money to cover the cost of nursing home care, though. Okay, so if you have a family member that's that looks like they may need long-term care in a nursing home, then your family or your friend or whoever it is that you see's on the verge of needing this, they need to come talk to us, because the way these rules are the way the rules work, it turns out that many middle-class people can qualify for Medicaid. However, the rules are complex, and also they're very fact-specific. So what we offer is a free initial consultation. We ask the client to bring in a lot of information when they come to the meeting, and then based on that more detailed understanding of their situation, then we'll look at it and see if we can assist them. And what's that assistance feel like? It feels great, because one of the worries that people have when they're trying to take care of an elderly mom or dad or brother who needs nursing home care, they got two big worries. One, how am I going to take care of mom or dad or this loved one? And that secondly, how and who is going to pay for this? And having a big financial drain at the same time we're worrying about someone's care is just extremely stressful and exhausting. So one of the things that we can do is help clients resolve how to deal with the financial side of this. And we've helped hundreds of families preserve assets, come up with a plan that gives them peace of mind. Okay, if we do these things, then we can qualify by so-and-so, and we can stop worrying about the financial side. So remember this, for your family and for friends, they make a grave mistake if they don't come and talk to us if they're facing this. Okay, mistake 4, funding not maintained or updated. Okay, so funding is usually, that word is usually used when we're talking about trust planning. And it's extremely important with trust. The reason that the trust has power, the reason that the trust is able to deal with your property and smooth out a lot of the problems that come with disability or death, is because the trust owns the property. So this means that the bank account, the investment account, needs to be in the name of the trust. It means the home needs to be in the trust. It means that lot you own needs to be in the trust. It means the timeshare that you have in Florida needs to be in the trust. It means that we need to get the property owned by the trust. And then we're going to talk a little bit more about this in a different angle in a minute, but beneficiary designations on IRAs and life insurance and annuities, we want to make sure those assets tend to be outside of the trust. But if they need to be ultimately controlled by the trust, then we need to make sure we've got the right beneficiary designation set up on these different plans. And this is the most common problem that people have. And so this lists a couple of things: refinancing your home or other real property, and the mortgage company didn't want the property to be in the trust, so you bought the house. It's got a mortgage on it, but it never was put back in the trust. So this is not good for your estate planning. That house, even though it's got a mortgage on it, needs to be in your trust. Call us if you have real estate that's not there. If it's not in the trust, then that property's going through probate. Now, if you have trust planning with us, you also have a pour-over will. This will it really just has one provision, and it says if you find any probate property out there, put it in my trust. But don't forget this: that's not automatic. You have to go to probate court, and your spouse or your kids are going to pay additional money, and it's going to take additional time if they have to probate different assets in order to get them in, get control of them. So. And that defeats one of your goals with this trust, which was to avoid that kind of problem. Probate in our office costs a minimum of $3,500 up to $7,000 or so. And it's going to take about 6 to 8 weeks to get the letter from the judge so you can sell the property or transfer the property. So we want to make sure that funding's done. So as part of thinking about this presentation today, look at your asset accounts and see how they're titled. You should be able to tell from your account statements whether or not it's titled in the trust. If it's titled in the trust, it's going to say trustee after it, or it's going to have the abbreviation for trustee, maybe TTEE, and then it's going to have the name of your trust or some words down there that indicate it's held under an agreement dated so-and-so. So you can check that by looking at your bank account statements and your investment account statements, okay? And then if you have any questions about how the beneficiary designation form on your IRA or a 401 or your annuities or your life insurance are set up, then you need to give our office a call. Okay, so this is just saying the magic of this trust and its ability to avoid problems if someone is disabled or if someone passes away or after you're both passed away and it goes to your kids. All that's working because it's titled in the name of the trust. So this is the most common kinds of problem. And so just to give you the flavor of this, I worked with a family and they had a lot of different assets. They had mineral interests. They owned land in West Texas. They had other assets. And so we were very careful about the funding when we initially set up the trust back in the early 2000s. And then mom passed away in, I don't know, 2005 or 2006. And so again, we went through a very careful post-mortem process, checked everything, and the son became co-trustee with dad. And so that was a great way to have, continuity through this whole process. And so 5 or 6 years later, dad passes away. So the son, he's co-trustee on all accounts. He's been taking care of things. He knows where everything is. He's got control over it. So he's setting up to do the post-mortem work and distribute the estate to himself and his siblings. And he goes to the bank and he tells the bank guy, he said, my dad passed away, here's the death certificate, and I'm the trustee and I need to access his safe deposit box. And the bank said, you're not on that safe deposit box. So this bank said, well, you can look in there, but you can't you can't take anything out. And so they let him look in there because sometimes safe deposit boxes don't have anything worth having in it. So you might be able to avoid the problem. But when he looked in there, there were gold coins in the safe deposit box. So we had to probate dad's will so that he could get a letter from the judge so he could access that safety deposit box so he could get that $20,000 worth of gold coins. But of course, he had to pay an extra $3,500 or so for the probate. So this is the way stuff sneaks up on people. And what was the problem? Mom and dad had that safety deposit box for years and years, and both husband and wife were both on it. Well, wife passed away, so it was joint tenants with right of survivorship, so dad had control over it. And he never thought about that being an asset, just like any other account. And so when he died, he was the only name on it, and the bank wants probate. Okay, mistake 5, acquired assets completely bypass your estate. So this is another version really of funding, but it's important to consider. And remember, one of the ideas with your estate planning is to get everything to flow the way you want it to flow as a blessing for your spouse and your kids, and to make it easier to manage all this stuff. Well, if you have accounts, so you have a trust, and you also have accounts that are in joint tenants with right of survivorship for the husband and wife. Well, those assets are going to go to each spouse. And then if the surviving spouse dies without doing anything about it, it's going to be probate property. If the surviving spouse loses their train of thought and puts one of the kids on that account as a joint tenant, when they pass away, that account will belong legally, technically, to that one kid. And if they had 3 kids, this may set up bad vibrations in the family. I'll come back to that in just a second. Life insurance and annuity benefits and IRAs and retirement plans. Families need to make sure that the beneficiary designations are correct and provide for contingent beneficiary. So, for example, for husband and wife, the IRA, in almost all cases, if the husband has an IRA, the wife should be the primary beneficiary for 100%. And then either your kids, if you have kids, or your kids' trust are going to be the contingent beneficiary. So whatever your planning is, we want to, in most cases, we're going to want to make sure that we've got a primary beneficiary and a contingent beneficiary on these IRAs and 401ks. On life insurance, since it doesn't have the same tax ramifications, the safest beneficiary in life insurance is usually the trust, assuming that fits with your overall plan, because then whoever survives will be, your family, your spouse or your kids will be the trustee, and so they'll have access to that no matter what. But at any rate, a lot of different things we've seen where this is not worked out. In the typical case, the problem was there was only a primary beneficiary in a life insurance policy, and that primary beneficiary predeceased the person who was the insured beneficiary. So just to give you an example of this, we had a man passed away, and we were doing the probate for the husband's estate. And so we got everything pretty well lined up, and the family was, they were in that mode where they were doing it wasn't a very well organized estate, but he had a will. And so the family was going through their, I call it it's like a treasure hunt where you have to hunt through the house for different things. Well, they finally turned up an insurance policy, and it was for $10,000, right? Well, the life that was insured was Dad's life. So if the beneficiaries had been the kids, it would have worked out fine. But oh, no. The life insurance policy was from years ago, and guess who Dad's beneficiary was on his life insurance? It was Mom. But Mom had died several years before. So the life insurance company wants a probate on Mom's estate in order to access the $10,000. So this is horrible. So that's another example. So they're going to have to pay us $3,500 to get $10,000 out of the life insurance policy. That's the kind of error that just annoys people no end and frustrates them in this process. So it deserves a good, hard look at this. Okay, this is talking about joint tenants with right of survivorship. So first, if you have a trust, it's probably better if you don't have these accounts. There might be some reason to do it, but usually if clients have a trust and they keep these accounts, it was kind of out of laziness. They didn't want to mess with that account. But keep in mind, if both the husband and wife passed away, got run over, that account's going to turn back into probate property. But also these accounts are free. We have clients that do a lot of will-based planning too. And a lot of times when people do will-based planning, in other words, they have a will, but they're really kind of hoping their family won't have to do a probate. And so what they do is they set up joint accounts with right of survivorship with their kids, okay? So the elderly mom, she has a will, but they'd rather avoid probate. So they've got accounts set up where one of the kids is the beneficiary or whatever, not the beneficiary, joint tenants with right of survivorship. So the nearby daughter that's taking care of Mom is joint tenants on Mom's bank account and maybe other accounts as well. The will says I leave everything to my beloved 3 children equally and outright. However, Mom ends up setting up all these accounts with the nearby daughter. So then when Mom passes away, the nearby daughter legally owns all those accounts because they're joint tenants who right of survivorship with her. And she says, you know what, I know that Mom's will said that, but she didn't really have much in the way of probate property. And I've been taking care of her all these years. And I think she intended me to have that. And so you can have a lot of spitting fights over stuff like that. I had a case that was just blatant. I had a deal where the husband, the dad, had an estate of about $1.5 million, and he had a will. It wasn't a trust plan; it was a will, and it left $200,000 in specific distributions to his grandkids, and then the rest of it was split 3 ways. Okay, so one daughter lives nearby, and the other 2 kids live way off somewhere. And so the daughter that was taking care of Dad gets his brokerage account was like $1 million or 1.2 or something. I guess it was $1 million. Anyway, there's assorted accounts that were worth about $1 million. She was the joint tenant on all those accounts. Okay, so as soon as he dies, she got $1 million of the $1.5 million estate. Okay, so she's also named as the executor in the will. So she distributes the $200,000 to the grandkids. Okay, and this was back when there was an estate tax. And the estate tax was close to $300,000. So she paid out of the probate estate $300,000. So the other 2 kids got nada, zip, zero, zilch, nothing out of this thing. Do you think people were happy about this? This was a killing deal, man. People were fit to be tied. Horrible. Okay, so you don't want your family to go through that. So you want to make sure you got the stuff set up right and you want it to work right when you pass away. Also keep in mind, the other problem we have, as you should probably know, everybody's living longer and longer. And so there's a good chance towards the end of our life, the last year or 2 or 3, we are not going to be running on all cylinders. And during that time, people who were formerly highly organized and kept track of everything and made sure everything got paid and taken care of, don't. And so there's a real chance for everything to go haywire during that period. Also, this is a great time for elderly folks to get married or have relationships that threaten their estate plan. So I want to make sure things are organized and we have selected good people as our trustees and executors and agents to keep this thing going and settle the estate properly. Okay, mistake 6, assets are unsuitable for family goals. Okay, this is talking about your nest egg, your life savings. We're talking about the golden goose that will sustain you through your retirement and may create a marvelous benefit for your children as well. So what are the problems that people have? So first thing let me tell you is that I have always been interested in investing all my life, ever since I was commissioned as a 2nd lieutenant in the Army. As soon as I had a decent paycheck, I started investing in the stock market. So I've always been interested. In the 90s, the Nobel Prize was given in economics to a man, Harry Markowitz, for modern portfolio theory. And his ideas and the ideas of the academics that were connected with this were far-ranging. And the general idea was there is a way to invest for individuals to invest successfully. But the way that most people invest is not calculated to be a winning proposition. Okay? Now, once I started the law firm, I was an estate planning attorney. I was not a financial advisor, period. I was just an investor. But as time went by, one of the appalling things that I kept seeing, because I would see people, at different stages as they went through from the time we initially did their planning through, dad passes away or becomes disabled and so forth, all these different family acts. So I would get snapshots of these families over time. And the sad thing was that most of them did not, their life savings did not fare well. So I noticed this, during the tech crash in 2002, Lots of families were hurt by this, hurt bad. And of course, in Houston, a lot of more families were hurt bad because of Enron and all that collapse connected to Enron and all that big scandal. And then we had these people like Sanford and that ended up, lots of people lost millions and millions and millions of dollars with bad investment advisors. Well, anyway, in 2008, I watched this again and what it did to my estate planning clients. And I just thought, my goodness gracious, this is a shame. There is a better way to handle things. And so I decided to get licensed as an investment advisor and begin helping families with this problem. So let me show you one example of what I'm talking about. This is a report. It's called Dalbar Research. And this is a famous deal. This is a big time research outfit out of Boston. And their reports are published in the Wall Street Journal every year. And one aspect of their reports is this one. And this should give you an idea of how appalling the situation is for American families trying to manage their life savings. This slide shows, in the right-hand corner, it says 1987 to 2016 annualized return. And so the top thing says, okay, what did the S&P 500 index get from 1987 to 2016? Average annual return, a little over 10%. A little over 10%. What did the average investor, they're talking about the average investor in the United States who invested in stocks or mutual funds that invested in stocks. What was their return? Not even 4% per year. So that is what I saw over and over again, and worse, in my families that I was helping with their estate planning. And so this is so suboptimal. Now, if you're listening to this, you may say, well, I've done a lot better than that. I'm not average. You know, we're all above average, right? But believe me, this is a problem. And so you say, what is the problem? Well, most families don't have a system. There really is a better way to invest that's empirically tested. But most families don't have that. And secondly, there's no continuity in the family between the husband, the wife, and the children. So this is just a shame. And so if I can help you with this, give me a call and we'll talk about it. Chris, tell us about mistake 7.
All right, so mistake 7 is that the family is unaware of your plan or their duties in the plan. Now, this is a big one for me because I've been an active participant in my family's estate planning for many years, and it's really one of the things that inspired me into this industry because I've seen how important it can be to families. And so I'm very grateful that all the plans were discussed with me and that I know what the situation is, because you don't want your trustees or your executors to learn that they are your trustee or executor for the first time when they learn that you passed away and it's time to administer the estate. I mean, so think about it this way. In football, you know, the team huddles up first and then says break, and then they go to the ball, and the ball is hiked when the quarterback says go. You got to get together and have a huddle, and it's extremely beneficial to the whole family unit and the smoothness of how the estate planning is actually administered once something happens to you. There we go. And a big reason for that is a lot of the smoothness comes when people are aware of what their role is going to be or what their role might not be. So you might have a responsible child that thinks that they have a larger role than what they have. And they might become offended when they realize they didn't. And they only learn that after you're gone and they wonder why. And then there's fighting between the siblings. It happens a lot. I've seen it personally and I've seen it professionally. And so you want to avoid family feuds. And one of the best ways of doing that is open and clear communication. I mean, it's true with any relationship, right? And so you also want to talk probably to the people who you think are going to be the biggest cause of trouble. And it might not be that they're, unruly or anything like that. They may just be strongly opinionated about their high capability of managing the estate, but you just haven't assigned them that role. And so communication, extremely important. Where is that thing? There we go. Sorry, guys. Okay, another issue going along with this is that personal items can be one of the biggest points of contention for families, because there's items that have sentimental value. They might not be worth much money, but they are extremely valuable to the family members for personal reasons. And it's easy with things like that for multiple beneficiaries to think that they were promised that item is rightfully theirs, when in fact it's been promised to another. Or potentially this even happens where, especially in later years, the same item gets promised to multiple people, and then there's going to be a fight, and it's just easy to tell. So one thing I encourage all of our clients to do is that if you did trust-based planning with us or will-based planning, you should have gotten memorandum pages, and your specific distribution article tells your trustee to look and see if there were memorandum pages left behind, and to respect those wishes. That's a great way. So all you do is handwrite a description of the item, who you want to go to, and sign it in front of a witness. It doesn't have to be done with an attorney or done with a notary. It's just a simple way of making your wishes clear. And it might also be a helpful way for you to remember who you promised items to. So a lot of families overlook that, and I encourage you to use it.
Well, also in that section or near it is a location list. It's sort of a grid where you can indicate where different things are. And I was thinking, I maybe had a nightmare about this, but I was thinking that if something happened to my wife and I, the husband and wife kind of get used to their own setup, but our affairs are fairly complex. We have a lot of accounts and a lot of different legal entities. And I can just imagine my son and daughter trying to figure out where things were, where to find stuff, where to find all those passwords, all that stuff we have. So location lists might be a great benefit for your spouse and for your kids in trying to organize your estate. And so that's one of the things that's included in there. Also, one other thing that I was thinking about was Chris was talking is for people who are coming in and doing trusts now, new trusts, or who are doing restatements of trust. A restatement of a trust is if you have an old trust and we're changing lots of things in there and kind of changing the structure of the trust, and we're adding tax planning or taking tax planning out or whatever, then we do what's called a restatement. And essentially you get a new trust. It's just dated back to the old day. But any rate, for people doing new trusts or restatements, one of the things we provide is a video that describes the client's estate planning. It talks about their estate planning notebook in general, and then in detail, it has the information on who the trustees are, the executors, the powers of attorney, and all that stuff is there. And the videos for married couples about 55 minutes, not short. And so this is another way of being able to, one, refresh your own memory, and secondly, coordinate with your family, have the huddle and say, hey, here's the overview of this thing. You're the named one. And then like Chris said, if everything's going equally and outright to your very pleasant and friendly children, that's one thing. On the other hand, if there's tension in the family for whatever reason, then your trustees and executors have a thornier job to do, and it deserves more thought.
Thanks, Bob. Absolutely. One more item about these personal inventory. It's not just physical assets. Think about your digital assets as well. You've got your photos that might be on the iCloud. your Facebook account, whatever, wherever you digitally store, let's say pictures and stories that are sentimental, make sure that your password is recorded somewhere. It's a good idea to have a spreadsheet that shows your most recent password updates. And you might feel a little bit uneasy about that, but keep it in a safe place, because that stuff is going to be extremely valuable for your kids to get access to. They are absolutely going to want to get access to those pictures.
That's something, see, I've been procrastinating about. That's probably why I had a bad dream about this.
Probably. All right, so this is the huddle that I was referring to. So we absolutely encourage, and my family does this, is a family meeting to discuss the plan. So you have your trustees, maybe even your successor trustees, your agents, healthcare agents, and it's a good idea just to run through the whole plan. Just like Bob said, if you've got the video, well, it's a great time just to show the video, and that'll explain just about all they need to know. But what it's not going to explain is your personal values as far as how you want them to manage the money, what values you want them to put first. And so, there's some of this just has to be taught by the family as to your personal perspective on life and how you want things treated. Things that wouldn't be written into a trust document. All right, now we're on to our last mistake number 8, and that is that your plan does not reflect your family values or life lessons. So leading right into that. Here at the Bond & Brown Law Firm, we do believe in a holistic approach. We're not just about organizing your finances. Said at the very get-go, we are extremely dedicated to making sure that this thing is going to work for you. And I think the best way that can happen is if you're not just passing along your assets, but you're passing along your family stories, your wisdom, and family values is an especially integral part of it. So I look at just my definition of integrity is having a defined set of values and following through and living by those values. I think it's extremely important that you express your values to your family members and remind them what's most important.
Or also your family history.
Yep.
We live in a lot of times it seems like families have lost the sense of continuity with prior generations. And part of that is that we may have been telling our children and our grandchildren about how we grew up and things we did and about our grandparents and so forth. And we know a lot about those things, and we know dates, and we know places, and we know events that occurred. But when we're gone, that memory is fading, and it's like our memory of generations just barely reaches back to the last generation. It doesn't seem to stretch back any further. So, for people that are interested in this at all, we have as one of the things that we now include with the portfolio is a place to record information about you and your own personal family history. And it takes the form of a lot of questions, and it gives you a place to write those out. And at least as a sort of summary of things that have happened to you, it's excellent. But it also might prompt you to add other things that are meaningful that you want to be kept or remembered about your family and your experiences. So, and when you think about it, it's like, okay, where should we keep this, or where should we tell the client, tell our children to find it? And so it makes sense to me that it would be part of that big binder. It's either the record or it tells them to go find the record and keep it safe for the future.
And so the big point is, you're so much more than just a name on a family tree. You want to be remembered for your stewardship of the family and how you took care of the family and the positive ways that you impacted the world around you. And it's not just the positive. You might want to talk about some of the hardships that you faced in hopes that future generations will learn from your mistakes and not make the same themselves.
Yeah. But you know, all the cemeteries, and I'm sure you've had the same insight. You know, you go to the cemetery, it's got the person's name on it. It says 1946-2020. It's like, is that all it was a hyphen? Right? So just seems like we should leave a more for the record.
All right, so bringing it all together, we've gone through all of the 8 mistakes that really can destroy an estate plan. And I just hope that some of these issues, that you'll be able to relate with them and, you know, think about each one that we've discussed about and think, well, could that have impacted my estate planning? And I'm either aware or even unaware of it. And so what we're trying to do is encourage you to think twice about your estate planning. It's too easy to get it done, set it aside, and then never look back at it again. Well, that's just not the way that a good estate plan is maintained and managed. So we want you to think about these things. And so on the slide here, you can see a listing of 1 through 8. Those are the 8 mistakes that we've talked about thus far. And each one is posed as a question. So think about each of these, and if any of them give you any alarm, or if you would just like to have your documents reviewed, then please give us a call. Our number is 281-448-4100. And so we have free personal consultations. And what we'll do in the consultation is review your documents that you have in place now, and we'll see, okay, if there have been any changes in the law, have there been any changes in personal circumstance? I mean, we'll go through the whole list, and we'll see if anything needs to be done. If nothing needs to be done, then that's fantastic. But if something does need to be done, then we will give you a quote for that specific work. And so we give upfront pricing, and we think that's very important just to how we operate as a firm. And so you should have all gotten an email from Mary Hicks, and the email had several documents on it, PDF documents. Those are helpful resources for you, and you can go through those workbooks and kind of work this through yourself also. But we really do encourage you to give us a call and schedule a free consultation. Also on that email, Mary listed several times that are available for consultations. So if one of those works for you, then fantastic, let us know. If not, we'll find another date that works.
And one other thing I'd like to give you, go ahead, you got something else?
Oh, no, that was it.
I just wanted to add another heads up. We're going to be moving our office. You know, I've been in the Greens Point area for 25 years. And so we've moved around from building to building here in the Greens Point area, but we've always stayed in the Greens Point area. Well, we're going to be moving in July to a new office that's located off of 249. Mm-hmm. So right now, you know, we're at I-45 and the Beltway. So our new location is going to be off 249, not too far from Willowbrook, if you know where that is. And there's a Perry's Steakhouse at Cutton Road and Cypress Wood. That's a kind of a landmark for many people that live in the Cypress Spring area. And that the new office is right behind Perry's Steakhouse. It's a really nice facility. We're going to have a real good facility for workshops in our office. And so one of the things that I'd also like to mention is we give a lot of workshops. And so, and I do a coffee with Bob, like I'm doing a coffee with Bob tomorrow. And one of the things the coffee with Bob is just kind of shoot the bull about estate planning, investment planning, or whatever's on anybody's mind. But one of the things that I'm going to talk about tomorrow is maybe how you analyze your situation if you wanted to switch from out of a traditional IRA into a Roth IRA. So talk a little bit about that Secure Act changes and what it might mean. So at any rate, we have a lot of workshops. The other thing is that now with the coronavirus, everybody's getting more and more used to using Zoom. And so for people who, as in the future, we're kind of thinking that if someone has a hard time getting to our office, then we'll be able to use Zoom meetings. And on Zoom, you can share documents, so we could look at, your trust or other documents with you. And also, we have the ability now, in some cases, I don't think this is desirable in most cases, but if someone was a shut-in or just couldn't drive or get around very well anymore, we're going to be able to witness and notarize documents remotely. So this is kind of opening up a new area that in some cases may be more convenient. It also may be convenient for initial consultation. So like if you had a question on one of these aspects and you weren't sure it deserved to, drive into the office and spending a couple hours with us, maybe it's a phone appointment or a Zoom appointment, and we could answer your question, maybe look at a document if that was relevant as part of the meeting. So I think this is opening up a whole new stage, although we hope we're going to see you, and we'll hope that our new office will be convenient for you.
All right, let's see if there's any questions.